Welcome to the CHYE in partnership with COL Live K-Factor podcast with your host, Rabbi Yehoshua Wordy, Director of CHYE. Each week we bring you interviews with amazing Jewish entrepreneurs sharing their challenges and successes. Their stories will inspire you to make the Keli to take your business aspirations to the next level. Welcome back, everybody, to another week of the K-Factor podcast with your host, Rabbi Wordy. Very excited this week. This interview is going to be taking place. We're reaching all the way out to the sunny West Coast, and we're talking with a very, very accomplished, very high-level business attorney, and that is Baruch Cohen. Baruch is an accomplished and aggressive civil trial attorney representing business matters before the Los Angeles Supreme Courts, the U.S. District Court, the U.S. Bankruptcy Court, and before Bais Dins across the country. Mr. Cohen was recently admitted to appear before the United States Supreme Court and is a member of the prestigious $1 Million Trial Attorney Group for trial lawyers who have recovered at least $1 million on behalf of their clients. And it's a real honor to have you today, Baruch. Thank you very much for joining the K-Factor.
Good morning. Thank you so much for having me.
It's a pleasure, and I believe our listeners are going to really enjoy this conversation from many angles. First of all, Baruch has a tremendous amount of amazing stories to share. Some of the amazing work that he does on behalf of Eretz Yisrael, which we're going to discuss later. But the lion's share of our discussion is going to be focusing on things that you as business people should know about to be careful, in order to set yourself up to, number one, avoid ever having to deal with litigation, and number two, just to do things successfully. And so we're going to jump right in, but we'll start from, in our classic style. Take us on a little bit of your journey. So, I understand, Baruch, that you grew up on the West Coast and you went to you went through the yeshiva system there. How did you end up becoming a lawyer? Tell us a little bit about that journey.
Actually, Rabbi Wordy, I'm a native New Yorker.
Oh, okay.
And I grew up on the East Coast.
On the East Coast, okay.
I went to yeshiva all my life. I'm from Far Rockaway, New York. Then my parents made Aliyah to Lawrence in the 5 towns. That was a big move.
Uh-huh.
And went from summer camps, yeshiva all my life, 6 years of Beis Medrash, post high school, learning in the Chavetz Chaim Yeshiva in Forest Hills, on a very high level, always entertaining the notion that I really wanted to be a lawyer. I fostered this desire while I was in yeshiva. During the breaks, I wasn't allowed to have, for example, the New York Times because of the inappropriate ads. So I was a little culturally starved. I was only allowed to have the Wall Street Journal. So during lunch, that's what I read. And I was going to college at night, going to Queens College. And during lunch, I would go to the courthouse, the Queens County Courthouse on Queens Boulevard to watch courts in action. And then I started going to Wall Street to watch higher level, more sophisticated cases going. And I was very enthralled, because if you learn Be'iyun, if you learn not only Gemara, Rashi, Tosfos, but you also learn the Mefarshim, you see the analytical skills, you start learning that, and you start observing that a lot of American law is very similar. So you'll notice that a lot of from yeshiva products gravitate to law, and specifically to areas of law like commercial litigation and bankruptcy, because of the similarities in the way law is presented. And while I was in law school,
yes,
I can tell you that while I was in law school, it was really the first time I was in the company of women and people who were not Jewish. It was a bit of a culture shock because I came to law school in Los Angeles. And it was a bit of a shock, but I was received very well. And no matter what job I had that I embraced while in law school, whether it be a judicial clerkship or clerking for various law firms while in law school, I actually clerked for a Wall Street law firm that had an LA office. I had no problem wearing my yarmulke, my tzitzit, etc. They seemed to embrace the notion of a yeshiva bacher working in the area of law. There was simply no discrimination, and it was truly a wonderful experience. And I joked when I was sworn in to be an attorney, the judge who swore me in, the Ninth Circuit Court of Appeals judge, said that while Baruch was in yeshiva, he learned about the law of the prophets, of Ezekiel and Daniel and Jeremiah. And then now that he's becoming a lawyer, he's learning the profits of law. And indeed, it is indeed a very profitable industry. And it's a cute little jingle that stayed in my mind all these years, the fusing of both worlds together, and to not really compromise one versus the other, and to establish strong values in both, so that one never feels that he's a hypocrite going into one industry while compromising the other.
That's great. So I understand that as you were coming to the end of your schooling, you had a tremendous opportunity to get in at a very, very prestigious law firm, which came as a surprise, and it was a dramatic story. Maybe you could share that with us.
Sure. I was a graduate of Queens College. I went to Southwestern University School of Law in Los Angeles. These are what we refer to as A- schools. They're not Harvard. They're not Yale. They're not Ivy League. And while I was in law school, I was a bit frustrated with the job opportunities that were being made available to us in our school. So I decided to take a drive down to the local Ivy League schools of Los Angeles to see what jobs were being offered. And indeed, there was a judge, a bankruptcy judge, United States Bankruptcy Court for the Central District of California, who was soliciting law school students only from Ivy League schools. Well, I applied. The judge himself called me back and said, "I don't understand. Can you read English, sir?" I said, "Yes, I can." The judge says, "Well, I specifically said that I'm looking for Ivy League students." I said, "Well, but for the fact that I'm not in an Ivy League school, I am an Ivy League student."
That's great.
And the judge loved the chutzpah and the confidence and hired me. And he was an African-American judge, and I had tremendous exposure to the legal community. And the judge allowed me to sit in on many, many courtroom cases, and judges got to know, and lawyers from all over the country got to see this Orthodox Jewish law clerk sitting next, not on the bench, but on a table on the side of the bench where the yarmulke sits, taking notes. And it made a positive impression, so much so that the dean of my law school approaches me one day and says, "Mr. Cohen, I don't know how you did it, but you finagled an interview with a very prestigious Wall Street law firm. No one in our law school has ever gotten an interview at this firm, and they seem to have solicited you." I said, "Well, that's really interesting. I vaguely recall the name of the firm, but I don't remember ever interviewing." The dean pulls me to the side and says, "Look, let me give you some unsolicited advice. You know, in law school, no one made any objection to your yarmulke or those strings coming out of your pants. But the dean felt that since this was a white shoe firm, white shoe is code word for not Jewish, Catholic. The Maine, the Harvard, the law firms like the McDonald's, the Kennedys, the upper crust element." And he suggested to me that maybe if you wear a yarmulke, it might hurt your chances of getting a job. So he suggested that I take the yarmulke off because it'll improve my chances. This was really the first time someone ever suggested that I take off a yarmulke. When I grew up in Far Rockaway, if a hooligan told me to take off my yarmulke, those were fighting words. And that meant that someone's going to get bloody. Mm-hmm. And the only time I ever took off my yarmulke voluntarily was for the shower or for a swim in the pool. And when I was in yeshiva, people sort of warned me, the first sign of your descent will be when you take off the yarmulke. So I was very torn by it. I asked other Orthodox Jewish lawyers in Los Angeles at that time what I should do, and almost all of them didn't wear yarmulkes. And one lawyer actually told me, quote unquote, "This is not what we do." So I went to a Rav. A Rav actually told me that Ramosha Feinstein has a heter that for Parnassa purposes, you're allowed to take off your yarmulke. This was written at a time when it was challenging to have Parnassa. So with the advice of others, I did the unthinkable. I took my yarmulke off, tucked my tzitzis in, tried to think like a Gentile on the way to the interview, and was asked to wait in the waiting room. And when the door opened and the secretary escorted me into the interview room, I was in for the shock of my life when the lawyer who was there to interview me was from this Wall Street law firm, and he was sporting a big black velvet yarmulke on his head, and his payas were neatly tucked underneath his yarmulke. I froze. His eyes darted immediately to the ceiling of my head. And Rabbi Wordy, what do you think was the first question he asked me?
Oh boy!
His first question was, "Where's your yarmulke?" And he begins to lace into me, and he says, "I saw you in court. I saw you wearing a yarmulke. I was looking for a Ben Torah, someone who was proud of who they are. And, this is a firm of leaders, not a firm of followers. I feel you sold out." He didn't even give me a chance to explain. He said our interview was over. He was sorely disappointed.
Wow.
I was in for the shock of my life. I was so numb. I couldn't feel which pocket my yarmulke was in. I really felt like I blew it. You should know, the guy, even though he was very, very harsh to me, he did help me. He had Rahmanas on me. He helped me get another job in another firm, but not in his firm. But at that moment, after the tears, and I did cry that day, after the dust settled, I pledged that is the last time in my life this is going to happen. I am going to lead my life in a way to be Makadeh Shem Shamayim, to honor God's name, to not compromise my values. And I came up with the following formula. On the chess set, everyone occupies a box. And those lawyers who told me that's not the way things go, well, they occupied one box, but guess what? I'm going to occupy my own box. And instead of following the lead of others and then following what they say are the way things ought to be, I decided that I'm going to write my own script and establish my own strength, and this is the way I'm going to be. So it was a life-changing encounter.
That's great. So that's a very powerful story. You took the breath away from me for an instant over there. So let's jump in though now to focus on our crowd over here, all young business people. You've been litigating for business issues for many, many years. Let's go through like a few bullet points over here. For every business person should know key things in order to avoid getting into trouble to begin with. So you sent me a little bit of a list to as bullet points ahead of time. So let's go through. Let's see how much of this list we could cover in the time that we have over here. So the first thing you mentioned is something called document everything and confirm everything in writing. If you could elaborate a little bit on what you mean by that.
This is perhaps the number one rule of litigation. So much of litigation and fighting in court is spent over the ambiguity, is spent over, well, we really had an additional business point, a deal breaker regarding X, Y, and Z. And judges will always ask, did you confirm this in writing? No. Did you send a confirming memo? No. Did you put this in the contract? No. But the other side knows about it. And judges are very, very harsh about contracts that have what's called integration clauses. An integration clause means that everything in our agreement is contained in the four corners of our written agreement, and that if it's not included, it doesn't exist. And in fact, it's specifically designed to exclude what's called parole evidence and any evidence of oral conversations. So when striking a deal, never assume that the other side will act in good faith and will honor the oral portions of your deal. Err on the side of caution, not on the side of trust, and write everything down.
So
and
now
make sure that everything goes into the contract, and confirm things in writing, because even if it's not in the contract, there's still ways to get it in if you confirm it in writing.
Confirm in writing means what? Just what confirm in writing means.
For example, let's assume someone says the interest rate on this deal will be 3.5%. Okay, confirm it. Confirm it in writing. so that when you get the proposed written contract, and it's at a higher rate of interest that you agree to, remind the person that wrote the contract, no, we agreed at 3.5%, and here's the email. And the other side didn't object, or the other side said confirmed. Take the effort to confirm things via email. And we'll discuss in a second the dangers of emails in a second. But, when the transactional aspect of a transaction is properly documented, people like me who are the litigators really are out of business. The better the contract is drafted, the less the chance of there being a mistake or confusion or even fraud. When somebody makes representations to you, I'm going to borrow the money to use it for X, Y, and Z. Specify in the contract what the person pledged they would use the money for. Because if you subsequently find out that the person went to Las Vegas and gambled the money, or went and invested it in a highly speculative, loosey-goosey transaction, but it wasn't the real estate deal that you wanted, then you really have an excellent case for fraud, and it's been established and well documented, and you get the kudos for taking the laboring oar of making sure that everything is kosher. And it sounds harsh, but trust no one when it comes to drafting an agreement, because the nanosecond there's an ambiguity, guaranteed the other side will try to sensationalize and take advantage of that cloud and that unsurety, and take advantage and try to hurt you in the transaction. So ezehu chacham haroa es hanolad. Knowing that litigation tends to focus on the gray areas, be smart. Document everything lechatchila at the beginning rather than fighting b'diavad after the fact.
Okay. Point number 2 you make is listen to your internal compass. If it sounds too good to be true, it is. Please.
This is one of the yesoidistic machshavas. This is a key point. We all have an instinct. We all know whether the deal is too good to be true. The other day, someone came to me with a proposed contract, and it was just a pie in the sky with interest rates that were so not rational, so not reasonable. It was such a bizarre deal, and it was so onerous. Don't be seduced by the allure of over-the-top returns or very high rates of returns. Most of these transactions, if it's too good to be true, a judge will ask you at trial, what were you thinking when someone offered you 15% return on your investment? Or, for example, someone promised you that the transaction will be secured by real property, and you didn't bother, checking to make sure that it's secured. Again, you were promised things, you didn't bother to check, you didn't bother to verify it, you didn't bother to make the proper documentation. Why didn't you? Quick little vignette. I deal with a lot of litigation, and I met a polygraph specialist from the FBI, and he gave a demonstration of how this lie detector works, where they hook you up to numerous pods, and it tests every little aspect of your body, your blood pressure, your sweating, your breathing, etc. And they ask you basic questions to determine a flat line. Are you a man? Yes. Are you Jewish? Yes. Are you married? Yes. They don't ask you invasive questions that might embarrass you, but then they'll ask you a question which is a lie, and then you will answer truthfully, and perhaps they'll ask you a question to lie, and you'll see that the polygraph will go off the charts like an earthquake, with aftershocks. And the polygraph specialist told us, and one of the lawyers asked, is it possible to fool a polygraph test? And we've all been fooled by professional liars, in the community who sometimes use religion as a seduction to get you to believe them. and trust them when really you should be erring on the side of caution no matter how white the beard might be. And the polygraph specialist told me that nowadays the machine is so sensitive it senses the slightest tremor. And he said the following. He said that, you can lie to somebody else, but you really can't lie to yourself. And I thought that was a tremendous message. Deep down, if you know the transaction isn't good, and you know that you lack the experience to really perform, and what is being offered to you is astronomically phenomenal, and you don't really have the gravitas in business to justify that kind of return, and they're asking you to perhaps part with your chasana money, or they're asking you to part with, something that is bigger than you can chew, think twice. Call an attorney. Speak to a seasoned trial attorney who does business litigation, and consult first before you sign, and listen to that voice. We call it an neshama, That's that internal voice that the polygraph specialist said to trust. And if you were raised with a Torah education and you know right from wrong, don't do a transaction that you might regret later. Don't do a transaction where you're going to fear every time you see the NYPD driving down the block, you're going to fear, they're going to be getting you. Don't do a transaction that you're going to have to live in the shadows. Don't do a transaction which is gray area or fuzzy. If it's not straight and it's not erlach, straight, stay away from it. Don't do a transaction that will be embarrassment to you if it gets disclosed in the New York Times front page story. And this is sort of a spillover to the earlier story that I said earlier about the yarmulke. When you wear a yarmulke in your business, you're holding yourself out as someone with integrity. And don't do anything that will make a chil Hashem, a desecration of God's name, and don't do anything that would bring shame to your family. Be unscrupulously honest and have a reputation for that. And trust your instinct. Listen to the lesson of that polygraph.
Now, point number 3 you put here is pause before pushing send on an email. Is that a continuation of before, or is that a new point?
It's really a continuation and a new point. I'm sure you deal with emails, and many times you can receive an email from multiple parties. And sometimes you desire to respond to only one party. You write a snarky, sarcastic, perhaps insulting email to the intended recipient. But you didn't realize that instead of pushing reply, you pushed reply all. So now the other people who were on the email now see your true colors. It could ruin a business. It could ruin a transaction. It could ruin a marriage. It could ruin your reputation. It could subject you to litigation. You because you've now published a defamatory statement about Mr. X, he can now sue you for defamation. He could sue you for intentional infliction of emotional distress. I can't stress enough how, and by the way, it also is damning evidence, because instead of the intended recipient now knowing, maybe you're disclosing something, and maybe you think you're disclosing it only to your lawyer, but now you've disclosed something incriminating to other people. I can't stress enough how much litigation results because of the careless pushing of the send button, where the person didn't bother to think who he's sending the email out to. I've done so much litigation trying to clean up that kind of mess. And usually once the email is sent, it's like the exploded pillow feather. The pillow feathers are out, and there's simply no way you can contain the damage. You can't undo the damage. And if I had one wish, it would be that people would really, really have a warning sign, like a stop sign, on that push enter button, and have you think. Gmail has a function where you can retract an email after you send it, which I can tell you my clients have benefited from many, many times because I constantly push this issue of thinking and pausing before sending, avoiding a tremendous amount of problems by thinking of how will this email be responded to by other people. And by the way, this also spills over into another issue. You know, when you're communicating by email, not every conversation should be in writing. You know, my bubby used to tell me, not everything you think you need to say, and not everything you say you need to write, and not everything you write you need to send. And there's a lot of wisdom in my bubby's admonition to me when I was a kid. You know, some conversations should be personable. You know, sometimes when things are more formal, it chills the warmth of a friendship. You know, if you're deciding that you're going to be communicating in writing, take the time to have proper grammar, communicate properly, edit your work, make sure you're communicating your message clearly. Don't be loosey-goosey when it comes to a message, because sometimes people's feelings get hurt. You know, when it comes to a text, for sure, when messages are done via text, you know, I gave money.
Let me pause
to
you just for a second. I want to pause you just for a second. I wanted to go off script for two things. First of all, let's talk a little bit about that. I don't think people realize nowadays all social media conversations, all of these there's so many new forms of communication going on nowadays, and people are much more casual with those types of things. Those things are also considered, can be used against you. Like, what's the extent of this type of protectionism that people have to take?
Well, let me tell you, social media is a gold mine for people like me when it comes to discovery. You know, when I sue somebody, I befriend them on Facebook, I befriend them on LinkedIn. My investigator befriends them, engages them in conversation. You know, I was retained on a case of a woman who was run over by a drunk driver. She was a Catholic woman, and she was going to church. And imagine the jury appeal of a woman walking to church as she's getting run over. Oh. The girl the young lady who ran her over came from a very, very affluent family. Anyway, so my investigator, the night that I was retained, my investigator went to work immediately and discovered that on her Facebook site, this young lady posted a picture of her behind the wheel holding a beer bottle, and it said, "Drinking plus driving equals party!" Exclamation point. And the family subsequently took down that Facebook post the next day, but I already had secured it. And when the family learned that I had that Facebook post, the case settled immediately on very favorable terms to avoid the ugliness of a jury trial with this Facebook post being posted. Now, for example, another instance of a personal injury of a woman who was driving up a mountain and got into a debilitating car crash, and she exaggerated her damages in the lawsuit and said she can't go to parties, she can't go to amusement parks, she can't go to the pizza. You know, her life is over. Well, my investigator went into her Snapchat account, I think it was Snapchat, and secured pictures of her going to parties, and they were date stamped. Going to parties, going to pizza, going to amusement parks. And when we took her on direct testimony and she reiterated her testimony, we were able to impeach her. Wow. Because we established her social media posting. And people don't realize that every time they post on social media and they brag, you know, that could haunt them later. In fact, I have a practice that when I litigate a case, I instruct my clients to cease and desist from posting anything on social media that has anything to do with this case or their damages, because it's a gold mine for people like me, for trial attorneys. I know Rabbanim and rabbis, they encourage their students to stay off social media, as far as I'm concerned, as a trial attorney, I love social media. I can't get enough of it. It is the greatest gift for discovery and litigation when somebody volunteers their information on social media. So, but yes, it's admissible in court. There are ways to admit and establish foundations as to social media, and I do it all the time. And
but
people have to understand.
Is there no form, this is just like my own question, is there no form of communication that could be sacred? Like, I mean, if someone has a conversation with a friend on WhatsApp or whatever else it is, I mean, there's no way of claiming this is my private conversation. Like, well, how, is there nothing that people could do to protect any of their conversations?
Well, the law recognizes certain privileges like attorney-client privilege. If you write on your correspondence, attorney-client, then, if somebody wants to discover it later, they won't be able to. You have to do a privilege log. You have to explain that it's privileged. Or, for example, communications to your doctor. You have HIPAA rights. You're entitled to your privacy there. Or communications between a husband and wife are privileged. Communications between you and your Rav are protected by the priest-penitent privilege. So the law protects various privileged communications, but if A is speaking to B about the subject matter of a litigation and it doesn't fall under any of these protections, then putting it in writing could incriminate you at a later date. Usually oral conversations are perhaps the easiest to prevent from coming into evidence because it's he said, she said, and it's harder to prove because it's not in writing. But whenever you're writing something, use that seichel, use that muscle between your ears. Don't put things in writing that could kick you in the you-know-what later on. If it shouldn't be written, don't write it.
I got it.
Consult with a lawyer beforehand. And yes, social media is perfect evidence at trial. And I do it all the time.
I'd like to jump a little bit over here. One of the final points you talk about is inserting Bais Din arbitration clauses in your contracts. Maybe clarify for our listeners, like how that works. Let's take a step back before we jump into that. People should realize the power of a Bais Din arbitration before the need to go to secular courts. So maybe give people a little bit of a chinuch into the power of going to a Bais Din for legal issues, and then we'll track back to the inserting it in clauses for the purpose of going to a civil court.
Sure. Nowadays, Bais Din is portrayed by social media and by certain angry segments within our community as a failure or corrupt. I don't share that vision, and I don't share that experience. I've done over 90 trials at Bais Din to verdict, all the way to the end. And I can tell you from my experience that the Rabbanim that I have dealt with are the most ethical, the most experienced, the most careful. Quick story, when I was once sitting Shiva for my father many years ago, I was sitting in Lawrence, and someone said to me, "Hey, Baruch, I heard that you represent parties in Bais Din." I said, "I do." And the person said, "How could you do that? I heard they are all corrupt." Like, wow, that's a massive lashon hara on an entire world of Rabbanim. Don't know how you could ever undo that damage, but that's not my experience. I said, "Why do you say that?" He says, "Well, because I know a case where the guy could not have lost and he lost." I said, "Sir, in litigation where it's a toss-up, you never know how the jury's going to come down or how the judge is going to come down. You really can never guarantee the outcome. I've seen many cases where I've walked into trial swearing I'm going to lose and I won. And I've seen cases on the contrary where I thought it's a surefire winner, but there was some problem. The court didn't like my client or found my client not credible, and there was a problem. So I said to this person, "Tell me, this case that you're talking about, were you the Tovea? Were you the plaintiff?" He says, "No." I said, "Aha." "Were you the nitva? Were you the defendant?" He says, "No." "Aha." "Were you the witness?" He says, "No." "Aha." "So were you behind the scenes on this case?" He said, "No." I said, "So how on earth can you possibly declare that Bais Din is corrupt?" And I must say, that so much of the slander that you hear on social media or in certain organizational postings about Bais Din is simply inaccurate. They pick up the story at the end of the case. Bais Din is alive and well. Our Torah is very, very big. It can outlive and survive in any door, in any generation. The halachas still apply. And the halachas against Jews suing in our coast and secular courts still apply. And there are very talented dayanim. The question is whether you seek them out or not. You know, the mistake that certain people make is that they go to the quote-unquote local rabbi or the rabbi who they happen to know within their area code. But when you seek a great lawyer or a great doctor, you're not limited by who happens to live on your block. You seek out the best possible person that you can get. And when it comes to a Bais Din, seek out the dayanim who have the best possible reputation for integrity and sophistication. I will tell you that my experience has been magnificent, and I think that lawyers add a tremendous value to the Bais Din experience because we are trained at organizing our evidence and delivering cogent arguments. We, instead of just simply, vomiting 85 exhibits on the table of the Bais Din and asking them to sift through it, skilled trial attorneys bring that discipline to Bais Din, and it makes for a magnificent experience. The experience of Bais Din is very similar to the experience of private arbitration in the secular world, and it's also very similar to the world of court. In fact, a lot of the Judeo-Christian court common law stems from our halacha, and we should never feel that we're second-class citizens in a court judicial system because it all stems from us. So the notion that Bais Din is archaic is simply an archaic concept in and of itself. It's alive and well, and there are some magnificent, very sophisticated Batei Din that are experienced in not only Choshen Mishpat, but also in secular law, where they consult with experts before they render an opinion, Piskei Din. And if you seek them out, and I'm always available to consult with anybody as to which Bais Din to go to and which Bais Din to avoid, because not only does my vast experience in this area educate me as to the stars, but also the people who lack the experience, who have no business being in the world of Bais Din. Happy to guide anybody. And the world of the Bais Din is a magnificent one, and you're being Mekadosh Shem Shamayim by going to Bais Din. And if you do it properly, it can be an extremely good experience. I will tell you that the Batei Din in Los Angeles are magnificent, very well received, very well respected by dayanim all over the country and all over the world. And in fact, they have a very wonderful practice before they conclude the Bais Din, before they go into the Star Chamber to discuss among themselves the psak. They interview the parties and ask, do you feel that you got a fair trial? Do you know that every single trial that I've been to, the parties have said, yes, you gave us, you validated us. You made us feel like we had our day in trial. That's a very confident Bais Din, And when dayanim do this, and they look you straight in the eye, and they ask you questions, and they repeat your position for you, and they don't ridicule you, and they're not dismissive of you, and they make you feel valid and important that you took your case to Bais Din. It's a magnificent experience, and more people should do it. Now, the reason why I suggested the Bais Din clause, I get a lot of cases of internal disputes in mostos, in a shul, internal disputes in a yeshiva, president of a shul versus the rabbi, yeshiva versus the
Does this
principal.
apply also to business partnerships?
Absolutely. Two from partners, okay? And one will run to court to file the lawsuit. So now, just think about the finances of having to litigate and defend this case. The plaintiff's lawyer might be doing it on a contingency, so the plaintiff might not be spending any money. But now the poor defendant now has to spend money, and no lawyer is going to take a case on a contingency because he's not recovering anything unless he's going to be filing a cross complaint, or unless the lawyer is going to do it pro bono as a chesed or as a charity endeavor. So the defendant is now facing what? An initial $15,000 retainer. He might not have that kind of money, and that's just an initial retainer. Litigation can be very, very expensive. What do you do if a lawyer says to you, this case it might cost you $50,000 to litigate? Or what if there are so many witnesses involved? What if this is going to be a 3-week trial, and we might need to hire experts? You might need to spend $100,000 in litigation fees. That's an exorbitant fee for many people. Well, what if I told you that if you went to Bais Din, you could actually have a trial within 3 months versus going to court and having a trial in 4 years because of the backlog? And what if I told you that it's efficient and cost effective? What if I told you that going to Bais Din, you might be spending total $15,000 or total, $25,000? It's a better alternative. Now, you really have no protections. You can't force a party to go to Bais Din just because you're waiving your religious values at them. If they sue you in state court, you don't have a choice. Because if you don't respond, they'll get a default judgment against you, and then you're up the creek. However, if in your contract you insert a mandatory arbitration clause before a Bais Din, so now with this clause, if you're sued in arkos, in secular court, I can now, at very minimal cost, file a motion in that court to compel the parties to go to arbitration, because that's what they envisioned in the contract. And there's a 99% success rate because the courts prefer that parties go to private arbitration. They're backlogged. They don't need your case. In fact, they prefer that a party resolve this through alternative dispute resolution. So I tell yeshivas, and I tell shuls, and I tell business partners, be smart. Name the Bais Din that you want. I'm not a big fan of Zavla, which is sort of like a circus where Zebor Achad, Zebor Echad, where you choose one Rav, the defendant chooses another Rav, and the two Rabbanim choose a third Zavla. I'm not a big fan of that because it does invite a lot of abuse. But when you name a legitimate Bais Din in that contract that you have, you're saving yourself thousands of dollars of litigation fees because you had the foresight to think ahead. In the event of a dispute, we go to Bais Din. And it's a great Kiddush Hashem that you make in advance, because you're saying, as a balabas in the community, you're saying, I stand by the Rabbanim of my community. They're good enough to paskin shilas about what's kosher. They're good enough to paskin shilas about who wins or loses the transaction, the dispute.
That's a tremendous point, and I just want to clarify for people that are listening. They may not realize, and I'll let you elaborate on that, but a psak of a Bais Din is officially recognized by the law of the land, correct? In other words, elaborate for people. That people may not realize that actually Bais Din has a legitimate standing in the eyes of a secular court.
The answer is yes, and here's the elaboration. You see, a Bais Din award in and of itself, nobody knows about it. The courts don't know about it. There is no enforcement. There might be an internal community enforcement. For example, if a party doesn't agree to come to a Bais Din and ignores a hazmana, a summons, there can be a siruv, a form of contempt issued. But that's not the question that you just asked. You asked, a Bais Din adjudicates a case. It's a 3-month trial, let's say, and issues a psak, and the toveya, the plaintiff, wins. Well, how do you enforce it? Let's assume the judgment is for $100,000. Well, how does the plaintiff enforce it? Bais Din doesn't have an enforcement mechanism. However, the courts of every state in the country do. The courts enable you to petition the court after the Bais Din is over to confirm the arbitration award. And that is also a 99% track record of confirmation. There are exceptions. For example, courts will not confirm a Bais Din award or an arbitration award if there was corruption. But how often does one see corruption? Or if there was inappropriate ex parte communications between the dayan and the party. How often does that happen? Most rabbanim know the rules. They know you have to, it has to be above board. You can't, have dinner with the other party while the case is pending, etc. You have to disclose the connections you have with everybody. So most dayanim know it. And there is a mechanism to confirm the Bais Din award. I do it all the time. And once that the court confirms the Bais Din award, it now is given enforcement powers as if it's a judgment of the court. And now you can hand it to the sheriff. You can do a levy. You can summon the marshal, seize assets, put liens on property, summon the defendant to a judgment debtor's exam, etc. So yes, a Bais Din psak has power and authority. And people need to understand that it is powerful, and it's not something that can be overlooked. You can save a fortune of money by going to Bais Din. You can get a quicker trial, spend less on attorney's fees. And there's also some tactical reasons why you would want to go to Bais Din. For example, most courts will dismiss a case if the statute of limitations has run. A statute of limitations is a statutory period by which when you have to bring a case. You have to bring a malpractice case within a year or two, or a fraud within 3 years. But in Bais Din, in halacha, there's no such thing as a statute of limitation. So, if your case tanks in secular court because of a statute of limitations problem, you might want to consider cherry picking and forum selection and going to Bais Din, because you'll have a better chance of presenting your evidence. Or, for example, hearsay. Hearsay is an out-of-court statement offered for the truth of the matter asserted. You can't admit oral statements, hearsay statements in court. But in Bais Din, you can have hearsay statements. There's no restriction. But they didn't want to know what was said. Or another example, relevance. In courts, I object all the time when something isn't relevant, and sometimes the judge will exclude it. But in Bais Din, the dayanim want to hear everything. And you can object all you want on relevance grounds, and the dayanim will look at you and say, thank you very much, but we'll decide what's relevant and what's not. Have a nice day. So, Bais Din can be a fantastic device for arbitration. And if parties want to save themselves a fortune of litigation costs, they would be well served to insert a Bais Din clause in their contract. I have a clause. Anyone that wants to contact me, I could email them the clause for free. I'm happy to do it. And this is a way to ensure that you're protected. Imagine you're a yeshiva, you're a shul, and you have contracts with your employees. Let's assume you're going to be sued for wrongful termination. You have to terminate an employee. You have to terminate a rav or a principal or a teacher. Having a Bais Din clause guarantees protection. It also prevents, usually when you file a lawsuit, it's public record. The public sees it. The news gets wind of it. And not only is it public, but now there's the added dynamic that your dirty laundry is being washed in public. Whereas if you take the case to Bais Din, it's private, it's not public, and you preserve the integrity and the sanctity of the privacy of the parties. So it's really a fantastic technique, and many people should consider using it. And I'll be happy to share a Bais Din clause that's bulletproof to anyone that asks.
This has been a fascinating conversation, and really been a window into something very, very important. Baruch Hashem, we've been Meirich. We've gone pretty long over here on this. In the last few minutes over here, I just wanted to just discuss with you. You're doing some fascinating work for the land of Eretz Yisrael, right? You've created an organization called American Trial Journeys in Defense of Eretz Yisrael, and literally, though, in a 5-minute capsule, share with us a little bit, about your work on behalf of Eretz Yisrael.
Sure. A couple of years ago, during the Mavi Ma'amara
escapade
debacle,
right? Debacle.
I was very frustrated by the defense of Israel. The media was coming against Israel. The Arab voice was well articulated. Those who were speaking in defense of Israel were inarticulate. They were literally blubbering idiots. It was embarrassing, other than Netanyahu, who was eloquent beyond words. But many of these labor ministers and these ministers in Israel who couldn't speak English well were on CNN, and they weren't really articulating the voice for Israel. It occurred to me that, and by the way, I was very frustrated with the Jewish organizational defense of Israel, because I believe that merely defending Israel is not enough. You have to go on the offensive. Just like in litigation, you can't win a case. Well, you can win a case being merely defensive, but sometimes you got to go on the offensive. You can't win a football game by being on the defensive. You have to go on the offensive. So when there were allegations and accusations that Israel is an apartheid state, the best that these Zionist leaders were doing was saying, no, we're not, an apartheid state. They were just merely defending. I feel we should go on the offensive. And no greater profession to champion the plight of Israel are trial attorneys. We rely on evidence, not based on, fake news. Okay, we rely on good arguments. If the case for Israel were tried in the court of law, we'd win every time, because the case for Israel is a just case. The Israeli army is the most moral army in the world, and Israel operates under rule of law. So, I created a blog called American Trial Attorneys in Defense of Israel, and it can be found at attorneysdefendingisrael.blogspot.com. And I post pro-Israel pieces for judges and lawyers to read, and many, many lawyers and judges whose skewed perceptions of Israel were predicated on the New York Times, which was the worst abuser of the truth, and the LA Times, have gone full 180. And now, thank God, Baruch Hashem, they're very, very pro-Israel. And I have a policy. When I post things about Israel, it's nothing negative. I don't publicize scandal. I don't publicize negative. The only negative that I publicize are those Mishigoyim in Naturi Karta. These are Hasidim who feel that they need to ally themselves with Hamas and Hezbollah. To me, they're the Erev Rav, so I publicize what they're doing so that when they come to your community asking for charity, you should know who they are and you should know to throw them out of your house and not give them. But I publicize the importance of standing by Israel at all times. And this becomes really a great dynamic to one's career. Quick story, I was in LA Superior Court, and a Jewish lawyer approaches me, and he says to me, by the way, when you wear a yarmulke, you become the de facto representative and ambassador of the state of Israel, because whenever someone has a complaint, they go to the guy with the yarmulke. Guy comes over to me and he says, I can't understand why Israel does not make peace with the Palestinians. And the way he asked the question put me on the defensive. I don't agree to being on the defensive. As I said, I go on the offensive. I turned to this fine gentleman. I said, sir, did you ever have an MRI or a CAT scan? He said, wow, that's a very offensive question. I said, just answer the question. You ever had an MRI? He said, yes. I said, did they find a tumor? Yes. I said, let me ask you this, without telling me if it was benign or malignant. Did you make peace with your tumor, or did you go to battle with your tumor? And he looked at me, and his brain was processing my question. I went for the kill. I said, it's morally corrupt to make peace with a tumor. Israel has tumors and cancers within its borders. Hamas, Hezbollah, PLO, they want to kill Israel. Morally corrupt to make peace with tumors that want to kill you. It's morally just and proper to go to war with people that want to kill you. So with that type of attitude, excuse me, consistent with my approach to litigation, it's consistent with my approach to defending Israel, it's consistent with my defense of Torah values when they're being attacked by those who don't really know what Torah values are. I don't merely defend, I go on the offensive, and it's a very effective tool.
Tremendous. This has really been an amazing conversation. I have to say, you're very eloquent. All your years of experience have really shown through in this conversation. I'm sure that everybody listening really this has been mind opening for them, and these are things you should really think about. This is from the CHYE experience with all the people that are starting out in business and doing the new businesses. We all have trust and we all have good faith, and we do a lot of things just on those, with those feelings. But the truth really is when you're going into business, error on the side of caution. Make contracts, clarify things. These are all such important things that really could save tremendous heartache later on. Reb Baruch, I can't thank you enough for agreeing to be on this podcast, and I'm sure that everybody listening to this really is going to walk away with a whole new perspective. And shekayach.
Thank you so much. If anyone wants to receive the Bais Din clause, my email is bcc4929@gmail.com. And please feel free to connect with me on Facebook and LinkedIn and let me know that you heard this podcast so that we can further a connection and a relationship.
Wishing all of you a tremendous hatzlacha, Mechael El Chayil. In partnership with COL Live K-Factor podcast with your host, Rabbi Yehoshua Wordy. We look forward to bringing you more amazing entrepreneurs to share their stories. See you next week.